Hello and welcome to our lecture on the Second Amendment right to keep and bear arms. This is an area of law that has created a lot of tension in American politics over the years, not just recently, but certainly recently. And we're going to look back at the Supreme Court's treatment of this amendment. There are some important cases that lead up to the later cases, most recent cases in which the Supreme Court has incorporated the Second Amendment to limit the power of the states through the Due Process Clause of the 14th Amendment, and has also interpreted the right to bear arms as an individual right that limits both the national government. Obviously, the Second Amendment limits the national government and limits the power of the states. So let's get going. Let's have a look. Here is the text of the original amendment. Now, when I say original, what I mean is the text that was submitted to Congress after the ratification of the Constitution for Congress's consideration. This amendment was assigned to a committee for review, and that committee altered it substantially, significantly. So here's the original text. The right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. Well, that's the original text, so let's look at the amendment that got out of Congress and was ratified by the states. Obviously, they changed it significantly. All of the colons are gone, and what we've got here is a well-regulated militia, being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Let's go back really quick and look. Okay, so here, the right of the people to keep and bear arms shall not be infringed is up front, followed by the militia clause, followed by the religiously scrupulous clause, and then in the amendment that comes out of Congress, the religiously scrupulous clause, which is we call today conscientious objectors, that's gone, and the two clauses have been flipped. That may or may not be significant, but it was significant to the Supreme Court initially. Okay, so how should we interpret the Second Amendment? Some people say we should interpret it according to present-day circumstances, in particular because of the increased violence among an ever larger population and ever more urbanly concentrated population, and also because of new technology that allows military-grade, military-style weaponry to be mass-produced and made readily available to the people. Also, people say we should interpret the Second Amendment according to present-day circumstances, which also involve a long-standing tradition of guns being used for sport and defense, and also what's not noted there is the importance of guns for a culture of passing on a tradition of care and conduct and also self-discipline from parents to children in terms of using guns for sport and for hunting and for defense. Here in Craighead County in Jonesboro, Arkansas, we have many sporting shooting sports teams. Most of them are associated with organizations like 4-H, and also we have a long history and tradition of hunting, and that being really embedded in the culture. So that really captures, I think, the conflict between people over the Second Amendment. So what was the original intent of the framers of that amendment? Certainly, they felt that government could protect people from many things, not simply protecting them in their homes or people protecting themselves in their homes, but certainly the existence of a militia. There was this sense that the amendment would remind people that the United States was strong, that militias could be used by states to counteract the power of the national government, and that was the purpose of those militias, to balance military might across the United States and the states. So let's look at this militia clause. At the founding, and we're not talking about the framing of the Constitution, although certainly militias were strong then, but at the founding, during the Revolution, militias were composed of all people who were capable of defending themselves and their states against foreign aggression. So militias were the people. There was this sense that that the people would engage in self-protection, but also in defending the state. This is because standing armies were distrusted. They were tools of tyranny, and and there was a sense that the United States Army could be used as a tool to oppress people. I'll give you an example of this. In the election of 1802, ultimately came down to an election between John Adams, who was then president, and Thomas Jefferson, who was the challenger. Uh, Thomas Jefferson ultimately won when the election was thrown to the House of Representatives, and they selected Jefferson over John Adams. And there was talk actually about not allowing Jefferson to take office among the Adams supporters. The response of the Jeffersonian Republicans, Democratic Republicans, was to say, if you don't allow our candidate to take office, we will march on Washington, D.C. We will seize the city and put him in office by force. Now, this was a credible threat because the tool that they planned to use was an organization called the Virginia Militia. It had been founded by George Washington, and it was a well-regulated militia, and it was in fact a more powerful military force than the United States Army at the time. So the words well-regulated there seem to imply rules governing the militia, and the fact that those words come first suggests to many people that the intent of the Second Amendment was not to provide a personal right, but to limit the power of the federal government by creating the power of the states to regulate militias, to create military forces such as the Virginia militia in the example I just described. The right to arms clause is confounding. Bear arms is a military phrase. So the right of the people to hold and bear arms, in that clause, bear arms is a military phrase, but it says the people, which implies individuals. So once again, we get the clause, the right to arms clause, sort of mixing militia service with a military service with the people. And it does seem that the amendment is very, very strongly emphasizing the militia part of the equation. But you can't get over the fact that there is the word the people there, the right of the people to hold and bear arms. Okay, so that brings us to two approaches to the Second Amendment, and these are two approaches the Supreme Court has taken. The one is the collective approach, which characterizes the Supreme Court's approach to the Second Amendment for most of our history. And the second is the individual approach, or the personal right approach, which the court has taken in the last decade. So here are some key court cases that you should be aware of. The first is a case called United States versus Cruikshank. This involved a conflict during the Reconstruction era occurring in Louisiana during the 1872 elections, in which the Republican and the Democratic parties both determined that their slate of officials had won the election. The Republican majority legislature was the one that you might say was in power only because of the Reconstruction era, and the Democratic-led slate of officers was really put up by a organization called the Ku Klux Klan. Now, the dispute led to all sorts of violence, including something called the Colfax Massacre, in which 105 African Americans and 3 Caucasians were killed. After this happens, a federal judge rules that the Republican majority legislature should be seated, but the Democrats then arm themselves and attack black Republican freedmen who had gathered outside the Colfax courthouse and were attempting to resist the efforts of the Ku Klux Klan to put the Democrats in office. So the Supreme Court rules that what had happened here was an attempt to deprive African Americans of their right to freely assemble and their Second Amendment right to keep and bear arms. However, the court ruled that while the Ku Klux Klan had attempted to deprive blacks of their right to keep and bear arms as it relates to a militia, the conviction of members of the Ku Klux Klan was wrongly decided based on the Due Process Clause of the 14th Amendment. That, according to the court, only applies to state action, and here what we have is an individual action to deprive persons of their rights to keep and bear arms. That can only be decided, according to the Supreme Court, by a state court. So, yeah, there was no basis for the action because the 14th Amendment only applies to a state effort, not a private effort to deprive an individual of their rights. Okay, so that's a bit of a confusing case. The court says basically that the Ku Klux Klan had deprived blacks of the right to assemble and bear arms, but then they said that right to bear arms is not part of an individual and a personal right. That's part of the meaning of due process. Another one, Presser versus Illinois, occurs 10 years later, and this upholds the idea that the states can regulate private military groups, that paramilitary groups and private groups are under the regulation of the state, but the court refuses to incorporate the Second Amendment. In other words, it refuses to say that that amendment is part of the meaning of due process in the 14th. Now, what the court is saying is that the Second Amendment clearly speaks to the state power to regulate private military groups. And then the last case is United States versus Miller. Huge gap in the jurisprudence. But Miller was a case involving two small-time criminals, hoods really, who were transporting firearms that the federal government had banned. They were shotguns, sawed-off shotguns, and the federal government had banned the movement in interstate commerce of these guns. And the court asks, does the National Firearm Act violate the Second Amendment of the Constitution? The court says no, it doesn't. And the court votes 8-0 to uphold the National Firearms Act, which prohibits movement in interstate commerce and private ownership of certain types of weapons. In particular, these weapons were used by the mob primarily. The court says, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument as a sawed-off shotgun. Certainly, it is not within the judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. So once again, the court takes the militia-centric approach to the Second Amendment and says a sawed-off shotgun cannot be considered part of the kinds of weapons that people would use as part of a well-organized militia. And it has nothing to do with the common defense. Therefore, the United States government can regulate it and ban it. So since Miller, we've gotten a few cases. 1980, the Lewis case prohibits gun possession by convicted felons, even when their convictions are overturned. So they say that people who've been convicted of felonies in U.S. court they can be kept from possessing guns because of their status as felons. And then we get in 2008 to District of Columbia v. Heller. This case was important because it Now, it's a case involving the United States government, not the states, but it's important because in this case, the Supreme Court shifts from a militia-centric interpretation of the Second Amendment to the individual right interpretation. So in this case, a police officer wanted to obtain a gun to keep in his house while he was off duty to protect himself. District of Columbia did not allow it, and so he sued, and the question before the court was, does banning handguns and the carrying of a pistol with a license violate the Second Amendment? And the court says yes. Very close vote, 5-4. Justice Scalia writes that the Second Amendment protects an individual right to bear arms, and that the militia clause doesn't limit nor does it increase the right. So he separates these two. The militia clause is now separate from the right of an individual to bear a weapon in self-protection as part of protecting themselves. Very different interpretation of the Second Amendment. Okay, the McDonald case was also important for our purposes, and you should look at that. McDonald versus City of Chicago. In that case, the court just extended the interpretation of the Second Amendment to include an individual right to bear arms. It extended it to limit the power of the states as part of the meaning of due process in the 14th Amendment. So look closely at that case also in your text. Thank you very much for listening.